Look, what we're going to do today is take the opportunity to revisit some of the comments that were made by the ACCC in their report in 2022 about the industry and potentially our failings, and look at ways that the CIRV have worked to prepare documentation that will be released to its members in order to provide a clearer form of communication with consumers to reduce the risk of misrepresentations being made at the point of sale to them. So the ACCC report was broken into a few parts, but one of the key focuses was misrepresentations made to consumers during sales or before a sale was made in relation to a caravan or RV. The ACCC was particularly concerned in relation to misrepresentations or perceived misrepresentations about warranties, separate warranties, availability of spare parts, tow weight, and performance capabilities, in particular off-road capabilities of the RVs. I've taken this table from the, I don't have a laser pointer, but I've taken this table from their report where you can see the vast majority of the misrepresentations were in relation to warranties, but then there's also quite a bit in relation to delay and after-sales support and repairs. So with regard to the consumer guarantees, these were the main things that were the focus of those misrepresentations in regard to warranties for two reasons. Partially because many people within the industry have an express written warranty in relation to their RVs or what they're providing, and they refer back to that, whereas the consumer guarantees are a slightly more nebulous guarantee or warranty because it relates to the reasonableness, the quality of the good and the specific circumstances of what's occurred. So there is a lot of space for confusion and dispute between the consumer and the supplier about what it is. I've cherry-picked some of the consumer guarantees from the ACL. I wasn't going to give you the whole list because it is substantial, but I thought it was important to just quickly go through these ones and reference them back to the key concerns from the ACCC. So Section 18 of the Consumer and Competition Act is just a broad prohibition of misleading or deceptive conduct or conduct that's likely to mislead or deceive in trade and commerce. It doesn't actually come with a consequence, it's just a prohibition that other sections of the Act then rely on to get a remedy. So that's why you broadly hear things about misrepresentations and misleading and deceptive conduct. In the Australian consumer law, there's a guarantee as to acceptable quality of the product, a guarantee as to the fitness for any disclosed purpose. Now, this could be a situation where a supplier or the sales rep of the supplier or the dealer at the time gives a representation of what the off-road ability of that vehicle is or what off-road means, and then the consumer, the warranty material from the actual manufacturer doesn't extend that far. But it gets to a point that because that representation was made to the consumer at the sale point and it was relied on by that consumer at the purchase of that vehicle, and they then went and took that vehicle and used it in that terrain and it didn't have the performance capabilities to work, that the supplier is in the hot seat without any ability to or recourse to the manufacturer. We also have the guarantee to supply goods by description. So if you're saying you're going to supply something and it's going to look like a certain way, you've got an obligation to meet that. And you've also got the guarantee in relation to the repair, the ability to gain access to repairs and spare parts for a reasonable time period, and the guarantee to supply things within a reasonable time period. So immediately from this list of guarantees, you can see how it ties in to the main concerns that the ACCC had in relation to misrepresentations or perceived misrepresentations being made at the point of sale. I put that slide in twice, just for you guys. So as I mentioned before, it's a more nebulous component of whether or not a consumer guarantee applies as opposed to an express warranty, because you're looking at whether or not it's reasonable that a repair is necessary or a defect has occurred in the vehicle. Now, the ACCC helpfully provided a rather vague view in relation to how long they thought a RV should be major or defect-free or free of major defects, and that is the very, very clear description of several years. So, look, you can understand why, because honestly, this is the kind of legislation where you go, it's the vibe.
You went to school a bit longer than me, so you obviously got a few more degrees. Several years.
What does that mean?
Well, what would be your interpretation of several years?
Well, if someone asked me that told me I could have several chips, it would be a handful, as big as I could possibly grab. But the several years is over 3, I would say, because a couple, a few, several. But that is not a standard definition, and it waxes and wanes. Like, it's not a specific point. There's no cutoff. And the reason behind that is because what they say is, well, if someone spent over 60 grand on an RV, they have a reasonable expectation that they'll be able to use that vehicle for, well, if they look after it well enough, 5, 8, 10 years, in relation to a major defect. Now, obviously, we all know that if there is, when you have a Caravan or an RV and you first get it out off the manufacture line and you drive it, there's going to be some issue spotting for the first period of time in relation to how you load it, whether everything is still functioning, whether anything might wriggle loose, the very technical term there, while it's being transported due to vibrations. There's a lot of stuff, there's teething issues that you have to look into, but they're not necessarily major defects. A major defect is something where it effectively has to be replaced. But it's vague, and the consumer doesn't know entirely what it means. The industry doesn't know entirely what it means. It's very case specific. So it comes back to a reasonable person and what they would think. That is the legal definition. We're looking at a reasonable person and how they would perceive it.
I shouldn't interrupt there.
No.
So would that be fair to say that until it's tested in a court of law with someone who went to school a little bit longer than you with the funny looking hairdo would make that decision based on what's in front of you? So
generally, the position is the onus of proof is on the consumer to show that the defect is major and it's a reasonable period of time that it should be replaced within. Sometimes the ACCC or the Fair Trading organisation might get involved to assist, but yes, until there's a determination, we don't know. And it's very rare for things to go all the way to VCAT to an actual determination. There's not a great deal of case law on this type of thing to give you an idea of what is actually reasonable for this specific industry. I mean, even in the ACCC report, just in VCAT, and it still hasn't gotten to trial.
No, I mean it was a case over a 7-year-old.
Oh, okay.
It
might be. Depends on what the defect is. Depends on how they treated it during that 7-year period. And it's fact heavy. So they can't have an overarching thing that just provides a clear answer. There's no distinct cut-off point. And everyone has a differing opinion on what a major defect is. You will get some consumers who are of the view that because they've got some fabric in their RV that is not the specific colour that they thought it was going to be, or it's faded over time, that's a major defect. Now, that's one that you can reasonably easily go back and say, well, sorry, but you're actually not a reasonable person. Like, that's not how you would perceive it. But there's more line and ball things as well, where it's something where you could continue operating the RV or running with the RV. It's not something that stops it from being on the road, but it's something that significantly impinges their ability to enjoy it. For example, if the air conditioner's bust, but then it's, well, what's a reasonable time for an air conditioner in an RV to be replaced?
When it comes with a third-party warranty.
It's tricky.
It is for us, because I mean, how many manufacturers in the room is, but the way I've been 30 years in the game, and I ask these questions all the time because I love these seminars, because we always learn, but we don't get any further with what is fit for its intended purpose for a fair and reasonable time. And then we're putting together a jigsaw where let's hypothetically, we're dealing with 100 suppliers, which all come with different warranties. So I've asked my lawyers, how would I write a fair and reasonable warranty for my product with 100, suppliers, which that, it's, as we've learned, is to have that relationship with your third party to say, hey,
this is not working. But the added complexity...
12 months for that, 7 years for that.
The added complexity as well is you can't then turn to the consumer and say, well, you go and deal with them. You go deal directly with them under their warranty. What's reasonable for their product? I don't want to be involved. Like, the Australian consumer law will not allow you to do that. If they come to you as the supplier or the manufacturer, you must provide the assistance. You must be the one that facilitates it. You are the one that has to make the determination whether or not it's reasonable.
I thought that was actually us dealers. Contract with the customer.
Yeah, so you're the supplier. So
Direct to the manufacturer.
the consumer can choose whatever's easier for them. The whole purpose of this legislation is to make it easier for the consumer to possibly seek a resolution to whatever's wrong or whatever they perceive is wrong. So they can choose to go direct to the supplier or the dealer who sold them the RV, or they can choose to go directly to the manufacturer. But neither the dealer nor the manufacturer can turn around and say, well, you should go via the dealer, and then the dealer will feed it back to me. Or alternatively, you should go to the specific company that provided that part.
But if it comes to a...
No, I'm here. I'm captive. You've got me.
If it comes back to, like, for example, major defect and, refund for the goods, ultimately that's with the dealer, isn't it?
If the consumer has gone to the dealer, that's the first. Then you have to deal with it as refunding, and then seek that money back from the manufacturer. But if the consumer then went to the manufacturer, they could potentially have a situation where they had to refund and then seek it back from the dealer. But normally, just from a practical and commercial perspective, they'd be trying to get their money back first, or they'd be seeking to have directing the dealer to refund the funds. But then it all flows back through, where did the money end up? So moving back. So, no. Please, no, I feel like these things are better when people ask questions. Otherwise, I'm just talking up here waffling.
And they've all got the same questions.
I'm like a dog with a big bone, unfortunately, because I've done plenty of these.
I'm just going back to the vibe. So, look, the Caravan Industry Association obviously recognise that this is a sticking point, and they want to facilitate or prepare something for the members that makes it as easy as possible to meet the expectations of the consumer, but also limit the risk that a consumer can come back and say, but you said this to me, when if it's just verbal, you don't know whether or not that's actually occurred. So in conjunction with us, we've assisted the association to prepare a contract of sale that forms 3 parts: a buyer acknowledgement form, a standard order form with all the details in relation to the RV and any trade-in vehicle, buyer, seller, etc., and standard terms and conditions of sale. And then also 2 additional, a guideline and a procedure, one being customer notification and guideline, and the other being a precedent or template consumer complaint policy and procedure for industry members. These are relevant. Why? Again, I've happily cut out little excerpts of the ACCC report. So the ACCC pointed out that delays in supply and repairs, the industry has to be on the front foot and proactively communicating to the consumers within reasonable time to let them know of any delays or the reasons for them. So the response in these documents has been this notification and communication guideline. It includes some template communications that can be sent off effectively by rote by the dealer or the manufacturer at set stages within the build or estimated time between when the purchase occurs and when the RV is meant to be delivered, so that there's a clear line of communication or an expectation of how frequently the consumer will be provided with an update. Now, obviously, this will vary depending on how long a period of time there is between them purchasing and the delivery of the vehicle. If they're purchasing something off the showroom floor, they're effectively going to be taking it away within a few days. But if they're actually getting something specifically manufactured to their specifications, well, I don't know, what's the lead time on delivery at the moment for a manufacturer?
Tomorrow afternoon.
Would not recommend putting that as the estimated delivery time.
Yeah, it can vary, but
Yeah.
obviously, yeah, so a lot of the time as a manufacturer, we are in the hands of the gods. I mean, through the COVID period where it was, 12 months plus, and we're relying on imported products. So, all of a sudden I ring up Barry, the fridge man, and he says to me that the fridges are on their way back to Ghaziland because the ship did a U-turn.
Or a ship suddenly got stuck in the Suez Canal.
So, a lot of the time.
But what the idea behind this policy is simply that it's a prompt for the dealer to check in with the manufacturer, and then at set points, the dealer then contacting the consumer to be like, hey, we're on track. At this point in time, we're on track for your estimated delivery time. Or there is a delay, and the delay is because of X. We can't do anything about it. It just provides a clearer communication to reduce the risk of consumers then complaining about not being notified or being notified out of the blue 2 weeks from when they expected to collect their caravan or RV. Because a lot of these things or these asserted misrepresentations boil down to communication and a knowledge gap between the people within the industry and the first-time RV buyer who's ready to roam and go up to Lake Argyle or something, driving 10 hours a day, straight out of the dealership and just start their journey. So they're not going to have the same understanding of the potential risks or the things that they need to troubleshoot before they go on their amazing journey. So this is a way that the industry as a whole can have not necessarily uniform, but a consistent check-in with the consumer to confirm or to notify them of delays, so they don't feel like it's coming out of the blue. Tow weight. It's a big issue, as I have learnt. So a lot of consumers were of the view that it hadn't been properly explained to them the tow weight of the vehicle they were actually purchasing. Now, again, this is, I think, possibly a knowledge gap, and I think that knowledge gap is shortening with education of caravan or RV purchasers. But one way that we've looked to address this is to distill in writing what the expected tow weight of that vehicle is, and also get the buyer to sign off before they sign the contract, which specifies what the tow weight is, a buyer acknowledgement form that confirms that they understand that if they modify their vehicle or the caravan or the RV, that'll have an impact on all of these things. So that further down the track, if something happens, if they're pulled up and they're like, well, your tow weight, you're over, you're not compliant. You've got a piece of paper with their signature at the bottom of it, and you say, well, we gave you we provided you with the information you needed in order to be compliant. You've decided to put the bike rack on after you purchased it from us. You've decided to add the extra water tank. Very useful, but heavy.
So one of the words that they love is reasonable. So is it reasonable to suggest that someone who has got the ability to earn enough money to buy a caravan would know that if they added 100 kilograms of water, they're increasing the weight of their van by 100 kilos?
It is reasonable, but if you've got it written down on a paper signed by them that they can understand, they can't argue whether or not it's reasonable because they actively knew.
Yeah.
It's not in writing and it's you're the expert.
Yeah.
You're the expert, you'll need to say no.
Yes, I'm willing to drop 130k on my RV, but I expect it to be perfect and operate without me knowing anything.
Yeah.
But that's not reasonable either.
No, but you don't want to have to. What we're trying to do is reduce the risk of it getting down to a fight of being whether or not it's reasonable. It doesn't matter whether or not it's reasonable because you knew when you purchased the vehicle. So you can't then say, well, it was misrepresented to me and I've suffered loss as a result, because you say, well, it's in writing, you signed it, and you signed underneath this to confirm that you understood that if you did modify the vehicle, that would have an impact.
But
And
could they not say, well, we had these, 5 or 6 forms that we had to sign when we bought our caravan, and that was unreasonable, that I understand all those forms when I signed them?
And that's
You know
why
what I
we've
mean? Like,
pulled
that's
out, no, I completely understand. And that's why we've pulled out this one pager, which is a buyer acknowledgement form that they have to sign before they sign the contract of sale with all the details of the caravan, which includes, I think, it's not here in front of me, but I think it's got 5 key points in it. Towing, off-road capabilities, modifications and the impact that it may have. And there's 2 other really good ones that I've forgotten off the cuff.
I think they're brilliant.
But it's just, the benefit of it is incredibly plain English. You don't need to be year 7 reading level. You can understand what it says. They're signing off on it. It forms part of the contract, but it's signed before they actually purchase the RV. So they can't say, I wasn't told before I bought the RV. Because you say, well, no, we had to get you to sign this first before you signed the contract. So even if you find the rest of the contract a little bit convoluted or you don't want to read through the 10 pages, you had this single piece of paper that stated these key things that you as an RV owner and driver needed to know. So you can't turn around to us now and say, but I didn't know. So it's all about reducing the risk of someone coming back and being like, you told me this. And also, look, in the communication procedure as well, one of the options is to email, well, one of the proposed communications is after the cooling off period of any purchase, to email them to confirm the purchase and attach the contractual documents as well. So the order form, the standard terms, and the buyer's acknowledgement. Because then they can't say, oh, but I lost them. It's like, well, we emailed them to you. Like, we've pre-provided you with signed copies of these. It's not something that we handed you a paper copy and you put it in your dash and it's gone now. So it's all about cutting off the potential arguments that could be made. Like herding cats. And also the standard order form includes the tow weight for the vehicle, post the modifications that are included within there. Now that I'm up here, I'm just going to write myself a note about estimates, because I think that's probably an issue as well, where there's obviously a level of variation in what something will actually weigh. Sorry, just note to self. Tow weight's a big one, particularly when people are trying to assert that they had to then buy a bigger vehicle to pull it, and so you should be paying them for that's the loss that they've suffered, buying a,
You wanted to buy it.
yeah, well, it was a good excuse. It was a good, something to explain to the wife and just be like, look, out of my hands, out of my hands.
I actually think we do a fairly good job now of telling weights and all that to car manufacturers who are.
Oh, yeah, there's the worst song.
It's not
But
us.
also the car manufacturers don't have anything in relation to the modifications that occur. Like, for example, if a tradie buys a ute and then puts the metal tool kits on the back,
That's what all the miners got done with the Prados, and that's why Petters and Old Mate came out with that GVM upgrade, because they were all legal out in the mines. They put 4 big boys, the rack, the fridge, the drawers.
sorry, when you say
Size
4 big
seven.
boys, are you talking about the miners or is that a specific?
Well, that's, they're all legal. That's what got them undone.
Yeah.
Yeah, so I think that's the issue. We give them the right weights and they, Ford say can tow 3.5 tonne, but realistically it can't.
Yeah.
But then they blame us because they tell us our caravans do.
Yeah.
So I think it's more of a car dealership issue.
No, it's
Car
not.
manufacturers.
It's not. We're the experts.
Yeah,
We
we sell caravans, not cars.
100%. I've had arguments with people where I just say, no, I'm not building that van for you because it's not going to be fit for your intended purpose for you and
Yeah.
your family. Period.
Yeah.
So the language we use when someone says, I've got a vehicle that can tow 3.5 tonne, is you need to ensure that you genuinely can tow 3.5 tonne based on any modifications you've made to that vehicle. Now, we don't know what you've done and we can't advise you on that. So you need to actually get that advice from
Yeah.
the vehicle manufacturer. That's a language we use, and we use that whenever the question of weight comes up, or what
Yeah.
can tow comes up.
Yeah. I wonder if, just getting feedback while I'm here, I wonder whether that's something to specify in the buyer acknowledgement form as well.
Yeah, I think that's.
You're obliged, because I do have in there at the moment that you're obliged to ensure that your vehicle is compliant, but I wonder if we articulate it more as a separate point and simply say, you have the obligation to confirm the actual towing capacity of your vehicle having regard to the modifications, if any, that have
They
occurred.
only hear 3.5 tonne, and then a lot of them now, you can put your ARB on finance, and so it actually is the dealer that's facilitating having all these extras fitted to the car, but they don't then say, well, now you can only tow.
Yeah,
Like, the consumer just knows it's 3.5.
yeah,
They
this,
haven't read the book that says the other bits.
it's a big book.
Yeah, but it's the interpretation from the, I've got a great article written in the Herald Sun. I've got it laminated, which I'll take to the Caravan show and have the argument with Bob, the big, that I can tow 3.5 tonne with my Ford Ranger, and I'll just flick out this and say, read the small print there. So by the time you put A and B and C together, your payload is Bob and his mate and no box of
Yeah.
stars. And they just,
You and a packed lunch, that's
I
it.
think it's about combined mass. You know, you've got GVMs and then you've
Yeah.
got UCMs. So
Look-
it's people understanding, because it's the RAM does it too. I remember when the RAM came out, I was at the Sydney Caravan show. I went up to one of the people from RAM. So I'm not being a smarty. Have you got any literature on your GCMs? And he said, oh, and I said, what can it really tell as a combined mass? He had no idea. When he got it out and got the calculator out, we worked out that the full payload in truck with tow vehicle behind was 3,720 kilo. Right, so the 4 can tow 4.5 tonne each utes each week.
Rear axle.
100%. So
Yeah,
that's what we're up against.
yeah. And it always comes back to, well, it was working fine until I got my RV and then,
We've come a long way
Yeah.
as an industry.
Yeah.
We definitely have. I mean, when I first started as a pimple-headed kid, it was single axle 300, tandem 400. Period. That was it. Right?
Yeah, exactly.
That was it. That's how we did it.
35.
Right? That's all you got.
Yeah.
Right? So obviously, as we've progressed through the decades, and then you get the odd bull, and I got the bull, and he got me good, and fair enough, because it was the start of the change.
yeah.
Maybe 10, 15 years ago.
Yeah. And I mean, with this one, for example, the ACCC say that only 4% of the people they surveyed back in 2022, 2021, only 4% ended up in a a VCAT or a tribunal situation to determine the matter. But I assume that when they say settled via the court or tribunal, it doesn't include any mediations or compulsory conferences that might have occurred along the way. And I mean, something can settle in a VCAT matter 3 years away after it's commenced. There's no decision from the tribunal because they settle at the door of the tribunal, as we will, but that's 3 years of heartache and stress and money for people like me.
Yeah, the hyenas.
I prefer vulture, thank you. So the other big issue that was highlighted is the fact that there's no definition or standardised definition of off-road. There's still not a standard definition of off-road. Yeah, it's about, and whether or not you have to be on asphalt. It's all, well, I would assume manufacturer specific to what extent they will say that the RV's capabilities or performance is. We don't propose to put words in people's mouths about what the vehicles can do. The people who make them have a much better idea than we do, me and my office. But what we have done is provided a specific section in the bar acknowledgement form where it can be hard typed or written in what the actual off-road capacity of that specific RV is. Now, someone can write in that it can go on dirt roads, or what's the most off-road that something can go in the industry when you say with a...
Well, you know, depending on what you want to call off-road. So,
Yeah.
you know, like off-road, is it an unsealed road?
Yeah.
Is it a, you know...
But that's what the purpose of this section of the bar acknowledgement form is, for the person who's selling the vehicle at that time to specify for the purpose of that vehicle what that off-road is. Because...
It's such a grey area though. Like you can have a dirt road, you can have a gravel road.
Yeah.
You can have a dirt road with light corrugations,
Yeah.
100 k's, we can have heavy corrugations.
Horrific, some of the roads.
Washouts,
Yeah.
all sorts of
Like, horrific.
stuff.
I did it
I wonder if
in
it's-
Unland 2 years ago, and I was horrified at
Yeah.
what we let people do to our vehicles. That road was putrid.
Yeah.
That was disgusting.
Yeah. So would you say, sorry, I'm just brainstorming here while I've got you as a captive audience. So with off-road, would it be better then to have exclusions or items that mean that the vehicle cannot be used for? So if you have a certain level of corrugation, do they define the level of corrugation?
It also depends on driver experience as well.
Yeah.
Like someone who's
Yeah.
take an issue
Yeah.
with extreme conditions, whereas if you're a novice and you take it there,
Yeah.
Yeah, I mean,
Arguably, someone who drives a road train is going to have better use of dealing with corrugated roads than someone who hasn't. No?
Because they just
Not their vehicle, not their problem.
don't want truck drivers on caravans at recreations.
Okay. So I guess it'd then be specific types of roads where it would just be like, you should not be taking your caravan or RV on these types of roads, no matter what type of off-road capability it has.
well, that's an industry. I mean, I've been in a lot of meetings where we're trying to come up with how can we be fair and reasonable in the definition of the roads for the people to take the product.
Yeah.
So, you know, like, again,
A lot of rental companies refer to it if it's a serviced one.
Yes.
So if it's a dirt track out in Woodward versus a dirt track that's been serviced or graded.
Yeah.
yeah, I suppose, and again, that's the thing, you know, like, it's about the definition of the perceivement of where, you know, if I say, where can I take your product?
Yeah.
I know someone that was done in court because they said this can go anywhere.
Yeah. Well done.
Bang, that was 20 plus years ago.
Yeah.
Right, because the salesman told them that.
Yeah.
You know, so again, when, you know, obviously,
Arguably now, depending on what they perceived as the anywhere to be, like if they tried to take it up Uluru, they probably wouldn't get up on a reasonable person would have believed anywhere extended to that point. But, I mean, there's some pretty rough roads in Australia.
that's
Could it be categorised? So could you have off-road category 1, 2, 3, 4, 5?
Yeah.
And then perhaps have a definition for each of those and say this is the capacity of off-road 2 or off-road, you know, just so that
The weather can affect that one
Yeah.
as well.
I know.
It would have, but it would have to be, this would have to be something at an industry level. You've got, guys have got the summit, don't you, in September?
Yeah.
I wonder if this is something that we brainstorm.
It's, I've been to the summits and brainstormed, but I've been sat on consumer.
But if we
councils,
create-
we've tried to
if-
come up, we've tried to come
Yeah.
up with it, we've just uncertain, because it's nearly like it's too hard.
Yeah. But the difficulty is if we make it, if we just accept that it's too hard.
I mean, yeah, I'm not accepting that it's
No,
too
no,
hard,
no.
but it's coming up with that formula of
Yeah.
what's fair and reasonable.
But I quite like the idea of categories because it can also be impacted by weather.
It's just like the road conditions, it's also the speed they're travelling.
Yeah.
I can take a normal long road caravan anywhere, on any road,
Yeah.
if I go, 10 kilometres an hour.
And
So it's these idiots that get out there who want to do it at 100 kilometres an hour, and wonder why things fall apart.
Yeah.
So
It's a shock.
There's the road condition, there's the weather condition, there's the speed that they're
Yeah.
travelling at, there's a lot of different variables.
So in the dealership, like, quite often the first question anyone else who's a dealer has heard this a million times as well, is will it do the Gib River Road? And my answer to that question is, you're asking the wrong question. Like, it's completely the wrong question, because the difference between the Gib River Road when it's perfect and when it's impassable is like this. So, can I do the Gib River? Yeah, sure. No, you can't. Like, it's just not a sensible question. So that's how we sort of open that conversation about conditions.
I wonder if it's also a matter of specifying, obviously there are certain roads that are shut through times of the year. If we have a section that says, look, obviously the off-road performance of any vehicle is impacted by speed, weather conditions and driver ability. Probably don't want to throw them under the bus there, but if you're a less experienced driver, you should not be taking it on more difficult routes. Because it almost sounds to me, just having this discussion now, that we're looking at almost like an information pamphlet over off-road. So we could have the categories, but then also effectively a frequently asked questions or education pamphlet for the consumer themselves that you can hand over and say, well, look, we gave them all the information in relation to the variables for off-road performance. We confirmed that this at a maximum could do this type of thing. They obviously couldn't be taking it over massive boulders. I assume there's no vehicles that can do that. I stand to be corrected. And notwithstanding that, they then used it in this way, and that was not a reasonable use having regard to the information we provided them. So it still gets to the point where we're relying on a reasonable person, but the dealer or the manufacturer can show and have evidence that they provided as much information as possible to allow the consumer to make an educated choice on what they were doing. We've digressed a little bit, but I think that one needs... It's, well...
You'd have to say that will eliminate like a significant proportion of issues by just doing that. It's not going to eliminate all of
No.
them because there's too many unreasonable people in the world that have unreasonable expectations that will fight these things. So you're not going to eliminate them all, but surely having, the categories maybe and that education around it.
But also it gets the
reduce
kind of people who would have tried it on to say, well, look, this didn't meet the off-road performance it should have done. If they read those categories and they're like, well, this was a category 3 and I know that I did category 5. It's like, how far are you going to push it?
But we don't know they're done category 5, because they keep saying they're done category 2.
You have to provide some evidence to say, like I took it on me. I mean,
Yeah, which roads did you go on?
I'm a caravan user.
Yeah. And also, it could, I guess as well, once the complaint is made, unfortunately, when it is made, one of the potential questions, I suppose, is, well, which roads were you on? And then you can reference back to what the qualities of those roads were at the time.
I think if you build it into the buyer acknowledgement form, at least there's that big word called education.
Yeah.
Which we have done over the last 10 plus years. We have really sped up the education of everything. So
Yeah.
it's about educating the consumer, educating people to make sure that you know, it's not buyer beware, it's what
Yeah.
comes out of your mouth beware.
Yeah.
Because you minimise your risk by educating the people.
Yeah.
That
And
buyer
distilling what-
acknowledgement form, this is unbelievable, because I've waited so long for this.
But also distilling what the representations are being made at the point of sale about the key things that are being complained about,
Yes.
so that it's not that they say, well, I was told by the salesperson. It's like, well, the salesperson told you that, but then you had to read this form
Yeah.
and sign you understood. So why didn't you then say, well, hang on, why did he say that? Did he clarify what he or she meant when they said that and how it played into this form? Because this form is part of your contract, not the nebulous statement that was made.
It's going to minimise your risk.
Exactly, and that's all we can do. At the end of the day, there will always be someone who is willing to go the whole hog and will do it on the principle of the thing.
Yeah.
And they're the worst people to get, because from a commercial perspective, there's got a point where you're like, okay, we disagree, let's come to a commercial arrangement so we can both move on. And they'll just drag it on and on until they get either dismissed by the tribunal, or the tribunal say, well, with some of this, we accept some of this, not all, and so we'll make an order for X, Y, or Z. Like, you cannot avoid these people. Disputes. The other thing we're trying to incorporate into these standard terms and conditions is the idea that disputes of a minor nature, well, two things. Creating a procedure for manufacturers or suppliers to use that has a set process that they can show that they've met to respond in a reasonable time frame to complaints that have made, and to obtain the necessary information from the person who's made the complaint to determine whether or not they should be doing something. But also, under the standard terms and conditions, providing that in the first instance in relation to some disputes, that it's referred to the Caravan Industry Association, that they can then appoint effectively an independent referee to review it to see whether or not they feel that it's reasonable. This is, in some respects, a placeholder for the Ombudsman, and the idea that there'd be a separate body within the industry where disputes between consumers, manufacturers and suppliers could be diverted to avoid the lengthy disputes in VCAT. But it does then provide an opportunity for those items to go to a third person and be resolved early on if the complaints procedure internally is insufficient. Oh, yes?
So we have someone who buys a Caravan Toyota and they decide to chuck one of our vans on the back. We call it an off-road vehicle. Now they go and tip another $60,000 into preparing a Toyota to drag the Caravan to where they want to go to four-wheel drive. They then take the Caravan or the trail through and they have issues with it. So what preparation, they're not doing any further preparation on the trailer, but they're doing it on the tow vehicle. So they're expecting the vehicle that we build, we don't know where they're going to take it, to hold up to the riggers that they're going to push it through.
Yeah.
So then they come to us and say that it's not fit for purpose.
And I think that ties back then to that, possibly setting up categories or a explanation of off-road and the expectations of when a vehicle, an RV, or how well an RV will perform in different environments and different off-road situations, and what that actually means, to then have an ability to refute them and say, well, you took our leisure vehicle, recreational vehicle, high over the hill, over very difficult road conditions, that you knew that you had to change your towing vehicle in order for it to be sufficient to meet those conditions, and you didn't do anything for ours. What did you think was going to happen?
That's right. Majority of little bars and winches and spotlights, roof racks and big wheels and tyres, and it goes on and on. And there's nothing done on the Caravan or the trailer. They're expecting it to
Do the same thing.
same thing, but they don't take their standard road car out to where they're towing it. So you've got two standards, then that would be fine. But if you've got one high performance and one standard,
Yeah, and it does come around, that comes back to this idea of off-road and what that actually means in this industry. Because it's different taking an RV to a caravan park as opposed to taking it somewhere up north.
Taking the tour tractor, or go and spend 60 grand on it and take it up to 60 days.
Yeah,
That's the difference. You're driving it to school or you're driving it to the desert. And that's like with our Caravan, no way off-road on it. The Land Cruiser's off-road.
yeah,
It's a four-wheel drive vehicle.
but there's,
What category do we stop in?
yeah.
So we probably didn't have to stop.
Well, what I'm getting from this is I think we're going to have a discussion at the summit and seriously distill, and it's going to take some time because of the complexities through all of this and the fact that it is not something that you can just have a standard definition for, because as you've all aptly pointed out, road conditions change, and as a result of performance abilities change. Because a road that in the dry is very hospitable and easy to go through, it's not necessarily going to be the same in the wet. So there they are again. Next steps. So there's still a lot to do. Based on this discussion, there's even more than I thought when I came into this presentation, but that is good. This has been educational for everyone. But the idea of warranties and disputes and setting up the industry ombudsman as a first port of call for resolving those in a speedy manner, and that would be disputes between consumers and manufacturers or dealers, but also potentially between manufacturers and dealers in relation to warranty claims. But just having something that could streamline resolution of those types of disputes by having a third party come in who's got the level of expertise required to review the materials available and say, look, on the balance of probabilities, X or Y, or a little bit of X and a little bit of Y. Repair facilities. So I understand that the industry associations across the country are looking to enter into an idea of a repair network, but setting that up so that if a representation is made that repairs can occur nationwide for a vehicle, that can actually happen, because based on the ACCC report, that was one of the issues that they had with people making representations that there would be repairs available throughout Australia, and then when a warranty claim was made, the consumer having a very difficult time in actually getting that work done or that repair undertaken because they were up in Queensland when it happened and they bought it from a dealer down in Victoria. So, and then thirdly, and again this is probably something to be discussed at this summit, setting up a standard procedure between dealers and manufacturers as to how they deal with warranty claims, whether the consumer goes in the first instance to the manufacturer or to the dealer, and how to streamline that so that there's a good turnaround or a reasonable turnaround time to respond to the consumer's complaints, but also there's consistency between how both the dealer and the manufacturer are acting. I know we've had questions throughout, but does anyone have any more questions? Oh, one more? One more for the road?
One more for the road. Now, obviously,
Which category?
this is a bit of out of left field, so this is just something I learnt the other day. So you've got your warranties, which under the consumer law stand.
Yep.
In the event that a product would go to the auctions under the hammer, where all warranties then are voided because it's getting banged down by the hammer, correct?
This is a second-hand vehicle at auction? New? Yep.
Could be new.
Yep.
Or still in its warranty period.
Mm.
Okay. Which is then called a transferable warranty, which you are by the law in Australia have to abide by, correct?
Yes.
Right. So if it was to go to the auctions, which then when it goes under the hammer by law, no warranties. Okay. Then in the event that you're a company that goes into administration, voluntary,
Okay, yep, this is getting convoluted, but yep.
new product, would the administrator have the powers or the right to take product to market, brand new, at a reduced price, and put in the disclaimer that all warranties are now third party. There is no warranty, say, against Goldstream due to the fact
Yeah.
that we have reduced the price of the product, which reflects obviously the no warranties on the product itself. But third warranties would obviously still apply, so the shoes I put on will be part of the package, which would be a third warranty. Would that stand up in a court of law?
So the price impacts whether or not it's the reasonable length of the warranty on the vehicle.
It's brand new,
Yep,
it's never been registered.
but the
You're
price is
gonna buy it.
reduced. The price is specifically reduced.
Price has been reduced by a percent.
And there's also limitation of liabilities for administrators when they step into a company. So that's not consumer law.
Right.
That's under a separate piece of legislation, which I can't tell you off the top of my head.
That's fine. It's
So
just that-
the administrator can limit their liabilities. The fact of the matter is, if they're coming in as a voluntary administrator, are we then looking to liquidate the company afterwards? Because if the company's gone, the consumer can't then go to them for their warranty claims in any event.
third party again.
They could go to the third parties who have produced the products,
Yeah.
but it's a slog, because as well the third party can say, well, we don't know how it was put in the vehicle, whether or not they met the installation requirements. We've only got our written warranty. We didn't actually sell it as a consumer product. We sold it to this, and they then used it in their product. You've given me a very tricky situation. And what I would say to you is, at the end of the day, if it goes to court, the courts have a soft spot for the consumer. So, I know, it's a shock. It's a shock. I know, colour me blind. So, I'd have to unpack that a little bit more and look closely at the legislation.
The other one about the option?
Yeah, I will.
Yeah.
Because you obviously at auction certain guarantees don't apply.
That's right. And then
But I don't think it's all of them that don't apply. But again, I have to go check Schedule 2 of
There seems to
the...
be a lot of product at auctions at the moment. Doesn't seem to be too many number plates that have been announced on the product.
Yeah.
So just tangential to that, one thing we do in our dealership
Yep.
is like we offer certain like lower priced second-hand vans. We will potentially offer them as is where is, no warranty,
Yep.
Now I understand under consumer law that's potentially problematic. But having said that, like I think most reasonable people understand what they're agreeing to.
Yeah.
And why they're agreeing to it.
Yep.
And in the off chance that we get one that has relatively minor warranty issue, we generally cover it rather than have it
Yeah.
right. But do I have any legal standing with that, with those statements?
Because it's a second-hand vehicle, the period of time that a warranty to the consumer it would exist is necessarily less, because it's not brand new.
But it's still reasonable. They're still not defined though, is it?
No,
Yeah.
it's just whether or not when you sell it. I mean, if you're selling something that's been refurbished, then the refurbishment, there might be an expectation that it would last for a period of time. Obviously, it's nowhere near what a brand new vehicle would be, or the brand new items within a vehicle. But if you're being very clear in your language and explaining that it's because it's secondhand and it has passed what would be considered the reasonable period for consumer guarantees, presuming that it's older than maybe 7 years.
Oh, no, well, like we're talking generally like around 20 years old or something.
Yeah.
Yeah, but you get to the thing where they pick up the 10K thingo, they drive it out and they come back 14 days later because the fridge doesn't work.
Yeah, but yeah.
As is where is though.
He's reduced the price to reflect, so it was worth 15 as
Yeah.
He's reduced it to 10, so they've bought it at 10, buyer beware.
Yep.
The fridge has a hissy fit, the fridge is 2K to replace.
Get an esky. But no, I think in those situations, if you're buying it at the age of 20 years, the consumer guarantees wouldn't. It's not reasonable to expect that the vehicle won't have
Good luck in court.
Well, a second-hand vehicle, it's a much easier argument. If that happened on a first-hand vehicle, you'd have no chance. But if you're saying, I sold them something, confirmed as is, where is, reduced the price as a result, confirmed that it was X number of years old and in our view was outside of the consumer warranty period, they bought it on that basis.
So if we said, if part of that's, we'll go to the fridge, because that's
Yeah.
a classic. We say, okay, well, you bought the van as is where is, you acknowledge that.
Mm-hmm.
How about if you supply the parts, we'll supply the labour to fit it?
Yeah.
Would that be something that if it did go to tribunal would work in our favour?
Yeah, well, it shows you've been reasonable. It shows that you tried to be commercial and provide a solution. It's always better to have shown that you offered something, unless it's just completely unreasonable. And then, as we have already touched upon, there are some people in this world who are completely unreasonable. None of them in this room, to my knowledge, but that's where it gets tricky. But yes, I have gone over time.
No, you're right.
Okay. Apparently there's afternoon tea.
No, it's been good. Weather around.
But yeah, look, what I got from this is I think we're going to have a brainstorming session at the summit in relation to off-road, because I need your knowledge to then be able to write something that a layperson can understand.
Thank you. Can we give her a round of applause?
Thank you very much.
Coffee and desserts, I hope this